Good afternoon, everyone. My name is Priya Keshav, and I'm one of the founders and CEO of Meru Data. Welcome to our webinar on cybersecurity audits under CCPA, key requirements and best practices. California has updated the CCPA regulations and have raised the bar for privacy and security governance by introducing a phased cybersecurity audit obligations for qualifying businesses beginning of 2026, and it's a phased rollout. The requirements for cybersecurity audit are part of a broader shift towards a more formal, evidence-based accountability on how organizations protect personal information and demonstrate reasonable security practices. In today's session, we'll discuss what the cybersecurity audit requirements are, what it means in practical terms, how to decide whether your organization may be affected, what must be reviewed and documented, and how to prepare for the upcoming compliance deadlines. As I previously mentioned, my name is Priya Keshav, and I'm one of the founders and CEO of Meru Data. We help simplify and sustain privacy programs for customers worldwide at Meru Data. I help companies operationalize privacy and build privacy by design into their practice. Previously, I used to be a managing director of KPMG's Forensic Technology Services in the Southwest US. I speak and write about trends in privacy, information governance, and AI governance regularly. Today, we have with us Austin Maines. Austin is a privacy counsel at Herbert, Smith, Freehills, and Kramer. He advises organizations on privacy, cybersecurity, data governance, and regulatory compliance. He works with companies to understand evolving privacy obligations, assess operational risk, and develop practical approaches for compliance with state, federal, and international privacy and security requirements. Austin brings practical legal perspective to the CCPA cybersecurity audit requirements, including how businesses can evaluate applicability, prepare internal stakeholders, and document audit evidence and translate regulatory expectations into a workable privacy and security governance practice. Welcome to the webinar, Austin.
Thank you, Priya.
Would you can get started with the presentation?
Sure, thank you. I'm going to try to share my screen if everyone would bear with me 1 second. Priya, can you see the slides?
Yes.
Great. So thanks everyone for joining. As Priya said, my name is Austin. I am privacy counsel for our US offices. I work out of the HSF Kramer Silicon Valley office. I have had a chance to work with Priya in the past for mutual clients on some privacy and cookie issues, and as privacy attorneys and IT specialists often do. And I'm happy to be with you all here today. I'm going to try to keep the exciting topic of cybersecurity audits relevant and interesting for you. I've chosen the who, what, where, when, why framework, but with your indulgence, I've bumped the when up a couple spots in the classic order because I think the timeline, especially for those of you representing larger companies on this call, is important and it will help guide our discussion. Starting with the who is covered. If you are a business under the CCPA and you are engaged in significant risk processing, you will need to comply with these cybersecurity audits. There are two avenues to compliance or mandatory compliance with these audits. One is the classic data broker clause in many privacy laws. If you are a business that derives 50% or more of your annual revenues, and these are global gross annual revenues, from selling or sharing personal information, you must comply with these cybersecurity audits. More likely, for those of you on the call, also if you are a business that has more than 26.625 million in gross annual revenues in the preceding calendar year, and during that same year, you process the personal information of either 250,000 or more California consumers or households, or the sensitive personal information of 50,000 or more California consumers, you must also comply with these audit requirements. Excuse me. So there's a few things to unpack there. That $26.625 million figure is a bit odd. When CCPA was first passed, the threshold amount was 25 million. There's a provision in the California codes that allows the legislature to raise the thresholds every other year. So since the CCPA was passed, it has now risen to 26.625 million. The sensitive personal information category of 50,000 or more consumers, for those that don't know on the call, sensitive personal data is a subset of personal information that is could be highly damaging if it gets released, or things like your biometric information, which can't change. So once they're released to the public, they're out there. Sensitive personal information includes things, data that from which you might be able to infer a person's race or ethnicity, their religious or philosophical beliefs, their mental or physical health, things along those lines. Biometric data, like I said before, face prints, fingerprint scans, iris scans. That's all sensitive personal information. So the threshold there is much lower at 50,000 individuals. So what does this all mean? What it means is that I think there are a lot of businesses who do not view their activities as especially high risk to consumers who might be caught up under this law. And I want to go through some common misconceptions to highlight that. The first and most common misconception that I hear throughout CCPA compliance work is we only have a few California customers, or we don't collect that much California personal information. We don't really operate in California. You've got to keep in mind that California has approximately 40 million residents, far more than any other state in the country, and certainly far more than any other state with a privacy law. Online identifiers like IP addresses, unique device IDs, unique advertising IDs, those are all considered personal information and they can add up quickly. So if you have a 27 million in gross annual revenues and you have a public website, it doesn't take much for you to have 250,000 unique visitors in 1 year to your website, which might trigger compliance obligations. Another misconception is we don't really sell or share any personal information. Sure, we use it for analytics on our website, but we don't really do much else with it. We're not a personal information driven company. These thresholds are based on the processing of personal information, not whether you sell or share it. Processing is a generic term in every privacy law that is incredibly broad. It basically includes any action performed on data. So whether you're collecting the personal information directly from that consumer, or whether you're getting it as a vendor through one of your clients or through a third party, you need to count all of those consumers to determine whether you meet the thresholds. Also, remember that sharing under the CCPA includes transferring personal information for the purpose of cross-context behavioral advertising or targeted advertising with third parties. This includes online IDs, like I said, and you should count the number of your website visitors from California to see if you qualify. Another common misconception is we're not a high risk processing company. We're not even a tech company. Any business can be caught up in these thresholds. Retailers, certainly, especially online retailers, of course, manufacturers, anyone, if you meet these thresholds, you will have to comply, not just if you're a tech company or you don't handle, a large volume or you don't do much with the personal data that you collect. Remember a couple other points. CCPA is the only state privacy law that does not exclude a business's employees from the scope of the law. Although I imagine if you have 250,000 California employees, you probably have to comply regardless. And CCPA only has a data level exemption for personal data covered by HIPAA or financial information covered by GLBA. In state privacy laws, some state privacy laws provide an entity level exemption whereby if you are covered by GLBA, for example, your entire organization is exempt from compliance with that state privacy law. CCPA and a handful of others have a data level exemption. What that means is that if you're in the healthcare space and you're collecting personal information that's also subject to HIPAA, you can exclude from these total counts the information that is subject to HIPAA or is subject to another exemption like GLBA. But if you're also collecting some health-related data that is not technically subject to HIPAA and is not personally identifiable information, or excuse me, protected health information under HIPAA, you will need to count those records towards the 250,000 person limit, or in the case of health data, more likely towards the 50,000 person limit for the sensitive personal information. So a key takeaway here, just to put it in perspective, there's 40 million residents in California. If you merely collect the names and contact information, things that might be found in old phone books, or more likely the online identification numbers for approximately 0.5% of the total California residents, and you have over 26.625 million in gross annual revenues, you will likely have to perform these audits. Quick practical tips for performing the audits. I mean, at this point, conduct an internal census. Determine whether you meet these thresholds. If necessary, have your data maps ready or create data maps. If you're on this call, you likely already have performed the data mapping exercise. Just determine how many California individuals' personal information you collect annually. Track the sensitive personal information separately. That 50,000 consumer threshold is much lower than 250,000. Monitor your revenues. Um, the way the statute is written, the revenue is determined for 2026 as of January 1st, 2027. And, we'll talk about this in the next slides, but if you have over $100 million in gross annual revenues at the end of this year, your audit period will begin January 1st of next year. So you want to build this note into your compliance calendar. And remember that the revenue thresholds might rise every other odd numbered year. So you have to check the California statutes to see what the legislature has done there. Most importantly, and you will hear this throughout this presentation today, document your analysis. Whatever you decide, whether the audit requirements apply or not, maintain a written record of that analysis and the data supporting it. Certainly maintain a record of any, reliance on legal counsel for that analysis. This documentation is your best defense in case of an enforcement action by regulators. So jumping ahead, like I said, to the when, businesses with more than 100 million in revenue for 2026 as of January 1st, 2027. Yes, that is how the statute is written. Your audit period will begin January 1st of next year and will run for the entirety of 2027. And a certification to the California regulators will be due on April 1st of 2028. If you have 50 million to 100 million in revenue for the year 2027, your audit period will begin. It'll be the entire year of 2028, and your certification will be due April 1st of 2029. And finally, 3 years from now, if you have 26.625 million to 50 million in revenue for 2028, your audit period will be the year of 2029, and your certification will be due April 1st, 2030. This is my mediocre PowerPoint skills attempt to create a visual representation of these timelines, but the deadlines are pretty specific. If you're on this call and your business will have more than 100 million in gross global annual revenues by the end of the year, you should already be thinking about the audit requirements and how to prepare for them. It's probably why you're here. If you have less than 100 million at the end of this year, you have a little extra time. But if you're going to have 50 million in gross annual revenues by the end of next year, probably about a year from now or the beginning of next year, you should add to your compliance timeline, your compliance calendar preparations for these audits. So some pretty practical tips. The first one is pretty obvious. These audits take months of field work, plus you need time to prepare, or the auditor needs time to prepare the report. So find your certification deadline and plan backwards from it. If you think you might be near a threshold, plan as if you will cross it. It's better to be prepared early. And that's because it kind of dovetails into tip three. You want to begin your gap assessments and your remediations for these cybersecurity audits before the audit period actually starts. Since we have the World Cup going on in our continent right now, I'll go ahead and use a term from soccer. You want to keep as clean of a sheet as possible, as they say on the pitch. You want to fill in these remediation measures, fill in these compliant gaps before the audit starts, so that these audits must be kept for 5 years. And we'll talk later about how they will be used for or against your company. So the cleaner they can be, the better. And it's a good idea to start fixing problems before the formal audit begins. This is very important. Tip number 4, you want to work with counsel on privilege for these audits. Cybersecurity audits and audit reports are difficult to keep privileged. The final versions can be difficult. It's not impossible, but certainly a lot of the pre-work and a lot of the draft reports privilege can be maintained on those. In fact, Cal Privacy was asked during the rulemaking process to add a line to the regulations. Cal Privacy is the California Privacy Protection Agency who is tasked with drafting these regulations, and they also have concurrent jurisdiction to enforce the CCPA along with the Attorney General. We refer to them as Cal Privacy now because saying CCPA and CPPA gets a little confusing with the acronyms. So they were asked to add a line stating that privileged documents did not need to be produced to the auditor. They didn't add the line, but their response during the rulemaking process was that nothing in the regulations requires privilege to be waived as part of this audit process. So it is possible and it is important to maintain privilege over everything that you can. So work with your legal counsel or your legal team to coordinate the preparation for these audits and the final audit report. And finally, tip five is fairly obvious. As with any major undertaking, you want to establish a compliance calendar with specific milestones, everything from vetting and retaining the auditor all the way through the final certification submitted in April of each year. So jumping back to the who portion,
One question that came up was, what if you have less than 26 million in revenue?
if you have less
I
than
guess
26 million in revenue, you won't have to comply with these audit requirements unless you are a data broker and more than 50% of your revenue is derived from selling or sharing personal data. Jumping back to the who in this framework, who must conduct the audit? Uh, the regs in section 7122 state that the cybersecurity audit must be performed by a qualified, objective, and independent auditor. The auditor may be internal or external, but either way, they must be a qualified professional with both cybersecurity expertise, audit knowledge and expertise, and that includes proficiency in recognized auditing industry standards. The regulations specifically list these four auditing industry standards as examples. The first two were not so familiar to me. I think they're more financially based or related. The last two, certainly the International Standards Organization, many people on this call, these are more cybersecurity related. Well, 27,001 of the ISO is cybersecurity related. You might be more familiar with these, but the point is that recognized auditing industry standards, your auditor must be proficient in. If you do choose to use an internal auditor, additional safeguards apply. First, the regs are very clear that the highest ranking auditor must report directly to an executive who does not have direct responsibility for the cybersecurity program. I think it goes without saying that the highest ranking auditor shouldn't be someone who helped implement or design the cybersecurity program or helped update it recently. If you use an internal auditor, then the same executive to which the highest ranking auditor applies must also conduct that auditor's performance reviews and, if applicable, set that auditor's compensation. So the regs are very detailed on this, which shows us that showing independence in these reports is important. If you have over 100 million in gross annual revenues at the end of this year, you should start considering whether you'll use a third party or an internal auditor now. And if you do need to make adjustments for an internal auditor, you should start making those organizational changes to their reporting lines before the audit period begins. So for large companies before the end of this year, so that once the audit period begins, there's no inference of pressure on the auditor to let things go. So some practical tips here. Document your vetting process for the auditor. Use the named frameworks that the CCPA provides. For the internal auditors, like I said, begin restructuring now or build it into your compliance timeline so that the auditor is completely independent internally before the audit period starts. It's a good idea to confirm the external auditor's independence in their engagement letter. No conflicts. They're not doing other work for you that are non-audit related services. It's also not a bad idea to memorialize the independence of your cybersecurity auditors by policy. You can do this in your written information security plan. You can have a separate cybersecurity audit policy. It's just another piece of evidence to show regulators, if asked, that you took the independence portion of this seriously. And also consider a hybrid approach. You might want an internal auditor to do an informal audit or a dry run before allowing an external auditor to come and do the formal audit process. Like I said, we'll talk about this later, but these audits, just like other cybersecurity audits or penetration tests, can become evidence for plaintiffs or for regulators down the road. They must be kept for 5 years, so it's not a bad idea to do a practice run before the formal audit begins. All right, moving on to the what.
Before we move, one question that came up again is, if we are a registered data broker and we do qualify for the 50% rule, but we do not qualify for the minimum dollar level, what is the timeline?
The timeline, I suppose, would be The you'd have to if the minimum dollar level 26.625.
Yeah, so you don't qualify for the 26.25, but you more than 50% of the revenue comes from sale or share of data.
I have to get back to you on that one. I'm sorry. I don't have that off the top of my head. So moving on to what the audit must contain, the scope and the deliverables. The audit must assess two things. It must assess the cybersecurity program itself, and also the implementation and enforcement of the program. As for the cybersecurity program, as is usual with many privacy laws, there's a bit of a sliding scale built into the law based on the size and complexity of your organization, the nature and scope of your processing activities, and the state of the art and the costs of implementation. So I don't want to say, certainly it's not mom and pop, but if you have 27 million in gross annual revenues and you're barely crossing the threshold, and you don't collect or handle especially sensitive personal information, you're not expected to have the same cybersecurity measures as the Amazons and Googles of the world. That's just sort of a keeping up with the Joneses that's built into many cybersecurity and privacy laws, and the CCPA audit requirements are no exception. The enforcement of the program, the regs are very clear. This is not just a review of policies on paper, and we'll get into this in the next slide, but the auditor is going to do a much deeper dive, including interviews and how well your paper policies are actually enforced within the organization. Some key definitions. Cybersecurity program, for those that don't know, means everything related. It means all the policies, procedures, and practices that protect personal information. Information system, this is important, means not only your own resources, but also third-party resources on which you rely to store or share personal information. So this includes your vendor management program. It includes your vendor due diligence process, and it also includes the cybersecurity measures of your vendors. You can see here that I have highlighted the word personal information, I think every time that it was used in these definitions. And the point there is that this CCPA audit is a bit different than other typical cybersecurity audits that you might already be conducting. Those are often certain system or threat based or IT asset focused, critical information systems. There might be critical information systems that the business absolutely relies on, but they don't actually ever touch any personal information. So this CCPA audit is personal information focused. So it should begin with a data map of the personal information and sensitive personal information that you collect, handle, store, or process. And it should also include any third-party systems that on which you rely to do that.
So in other words, and this is one of the questions too, what if I'm already doing an ISO audit? Do I need to do more things? And the answer is probably yes, because you need to focus a little bit more on the CCPA requirements around audits.
That's correct. The good point here is that there's nothing wrong with leveraging prior audits or audits that you're already doing. So you don't have to reinvent the wheel, but your auditor does need to take the ISO audit or the SOC 2 or whatever you might be doing and adjust that for any gaps that might not have addressed places where personal information is involved, and view it through adapt it to a personal information lens. And we'll get to there in a slide or two. Speaking of those types of audits, after stating that personal information is the focus, the regulations go on to list 18 cybersecurity functions or tenets that, if applicable, the audit must assess. So I've actually condensed it here. This is about 7 or 8 pages in the regulations with many sub-bullets beneath each of these 18 tenets. So if applicable, none of these will be especially surprising to cybersecurity professionals. Authentication, encryption, access controls, of course. But for example, number 14, if you're not developing any code, probably 14 won't apply, and the audit doesn't need to address that. But many of these are fairly typical cybersecurity measures that the audit must address if they are applicable. I'm not going to spend much time here. I think a lot of you are probably familiar with many of these, but you can sort of map these 18 functions to your ISO or your SOC 2 reports, or whatever it might be, in leveraging those prior reports to create the CCPA audit. A quick note on the objectivity and scope. There's obligations on both the auditor and the business. The business has an obligation to cooperate. The business must make available to the auditor all information in its possession, custody, or control that the auditor requests as relevant. The regs go on to state the business must make good faith efforts to disclose all facts relevant and must not misrepresent any facts relevant. The auditor, on their end, they have to have evidence-based findings. They cannot rely primarily on management assertions or attestations. And the regs specifically list evidence such as documents, testing, sampling, and/or interviews at the auditor's discretion. And we'll see as we move on that the audit report must also list the evidence on which all of the report is based, all of the findings are based. So some tips for preparation for the audit. Certainly, if you have over 100 million in gross annual revenues, you'll want to be doing this now. Build an evidence repository. Collect all of your documents, the system configurations, the audit logs, your cybersecurity training records, pen tests, all of your vendor contracts, access control logs. Collect all of that information in advance. And like I said before, maybe do a dry run and get it prepared before the audit period begins. As we just talked about, you can leverage your prior audits. Just make sure you adapt them to be focused on personal information. This includes the reuse of CCPA audits from the previous year. Certainly, as long as the auditor refreshes and updates those, you can rely on prior CCPA audits as well. Prepare your key personnel. It's not a bad idea to assign ownership to each of those 18 cybersecurity functions that are listed in the regs that I showed 2 slides ago. Cybersecurity professionals will be recognized pretty quickly who should be presented to interview or collect documents on each of those functions. Tip number 4 is important. If you're on this call and you're subject to CCPA, you probably already know, but every vendor with whom you're sharing personal information, you should have a robust data protection agreement in place with. Every data protection agreement should state that the vendor must give assistance to the controller, which is your business who is sharing the data, to meet their obligations under the CCPA. So start reviewing your vendor contracts and your DPAs now. Ensure that they give you the right to obtain the relevant information you need from that vendor in order to comply your own CCPA audit. Review your policies and procedures for accuracy and currency. Cybersecurity policies at minimum should be reviewed every year. If you have an outdated policy, that might create documented noncompliance in the audit report. Also, as we talked about earlier, if it's clear that you have something on paper but no one's following it or paying attention to it, that could also be a problem for the audit report. So review the policies and procedures and make sure they're being implemented. And then again, conduct a pre-audit assessment or a practice run and try to correct as many gaps as possible before the audit starts. What must be in the audit report? There are 10 specific topics that are different from the 18 cybersecurity functions that I listed earlier. These are in 71. I believe the 18 functions are in 7123 C as in Charlie. These are in 7123 E as in Echo. The cybersecurity audit must cover 10 specific topics. It must explain the scope of the audit, what systems and data types it covered, the methodology used by the auditor, the findings, both compliance and deficiencies, the evidence relied upon for each finding. It must identify a risk assessment. It has to identify remediation recommendations with prioritizations, red, yellow, green, or critical, high, medium, low. It has to have a timeline for remediating these issues, and it has to identify any corrections or amendments to any prior audit reports. Finally, there's a few housekeeping matters that are important. The report must include the auditor's name, their qualifications, and their certification. And it can also include up to 3 qualified individuals who are responsible at the organization for the cybersecurity program. Finally, if your business has had to give notification to any affected consumers for an exposure of their personal information in that previous year, you have to identify those in the audit report, or if you've had to notify regulators of the same, you have to identify those and either include a copy of the notices you gave to consumers or regulators or a description of that notification. You don't have to submit the audit report itself to Cal Privacy. What you have to do every year on April 1st is submit an annual executive certification of completion of the audit report. The certification by the executive must be signed under penalty of perjury, and the signer must be a member of the executive management team who's directly responsible for the cybersecurity audit compliance, has sufficient knowledge of the audit, and also has the authority on behalf of the organization to submit the certification. Going back real quick, but you do need to keep these audit reports for 5 years in case they're requested by regulators, and you should probably assume that they will be viewed by outsiders at some point. For the where category, there wasn't much to say about where, I admit, although just a quick note, the audit should cover any data systems on which California personal information is stored geographically. So if you have an AWS instance in Virginia or Washington, certainly those should be covered. But the point I've been making throughout is that I've gone to conferences and seen privacy regulators from different states all talk to each other. They all are in constant communication. They also talk to UK and EU GDPR privacy regulators or privacy regulators from around the world. They often bring joint enforcement actions across states or investigations. So you can expect that these audit reports may be requested by regulators in other states for the 5 years that they need to be kept, or they may be used as evidence in other jurisdictions. Um, Several states have made waves about enacting or considering comparable cybersecurity or privacy audit obligations. So you should keep in mind that if you have to perform California, just like with California, often creates the high watermark for privacy compliance across the nation for many companies because it's the most onerous in many ways. If you have to comply with the California audit requirements, you might consider just doing a high watermark and complying and performing the audit for all personal information from every state from which you collect it. It might save you some time and inefficiency.
One more question that has come is whether is there anything about AI mentioned in the audit requirements?
I did not see any. There's automated decision making in the audit requirements themselves. Automated decision making is in the California regulations otherwise. So I did not see that in the audit requirements, no.
Yeah, and it says everywhere there is personal information. So to the extent that there is an AI system that is consuming personal information, and for the most part, all AI systems are either, at least most of them are the applications that we see are the chat bots, the HR systems, as well as the on the analytics side, and pretty much personal information. There's plenty of personal information in these areas, and so I would say that it's already kind of part of the scope. I,
Yeah, 80. I'm sorry,
yeah.
Priya.
No, unless you disagree, Austin. Yeah.
No, I agree. ADMT is very well addressed throughout the CCPA regs. But this, again, the focus of this audit is personal information and everywhere it's stored. So if you're using an AI vendor, if you're using a chatbot where people are putting in personal information, that's all going to be part of the scope. It's sort of this focus is just on personal information itself, not so much the use of AI or automated decision-making technologies, which is addressed elsewhere in the regulations. As for the why, like I said, the audits must be kept for 5 years. Regulators have signals that these cybersecurity audits will be a priority. That remains to be seen, but I do know that there's a separate audit division now in the AG's office, I believe. And separate enforcement and audit divisions do exist. We can expect, with as aggressive as the California regulators have been, that they can demand production of their audit reports during any investigation. Um, if they get a consumer complaint, I'm sure they will demand to see your audit reports and whether the auditor wasn't independent enough or whether the audit wasn't comprehensive enough can certainly be used against you. And obviously, failure to conduct the audits or conducting inadequate audits may constitute a violation. More importantly, if you have any sort of data breach of any significance, you can assume that the plaintiff's counsel will seek the final audit reports to use as evidence in any litigation, and they're going to scrutinize, and their experts are going to scrutinize your cybersecurity audits and the measures you implemented at the time. And a deficient audit report or the failure to file one when there's a law that requires that you do so could easily be used by plaintiffs to establish that you failed to maintain reasonable security procedures. So practice tips, just assume the audit report. I mean, it's an independent auditor, but you want to make sure that the auditor gets things right. Assume the report will be reviewed by regulators and plaintiffs' counsel. Ensure the findings are accurate. And more importantly, have documented prioritization and remediation timelines, and then check those boxes once those, deficiencies are remediated. We've all seen many cybersecurity audits, they almost never come back completely clean. And that's, that doesn't necessarily mean that you don't have a mature cybersecurity program, but track your compliance and track your remediation. Um, Documented remediation is your best defense. Again, this is very important, especially given Cal Privacy's comments. Consider privilege for your pre-audit gap assessments or your drafts of your cybersecurity audits. Keep all of these separate from the final formal audit report so that if you do become embroiled in litigation later, you can likely limit the production to just the final cybersecurity audit, not all of the preparation work and all of the gaps you fixed beforehand. Um, it's a good idea to integrate your audit findings into your incident response plan every year as you update that, so you can address the known vulnerabilities before an incident occurs. And finally, you want to brief the board or the audit committee of the board on CCPA audit obligations and your findings. Lately, whether it's under the Caremark doctrine or under specific cybersecurity regulations, under SEC new rules, board oversight of cybersecurity is either required by law or is considered critical to the organization. Also, board oversight demonstrates cybersecurity governance maturity. So, brief the board as needed or the audit committee on your obligations and your findings. So, just in quick summary here for the how of the five W's and an H. Um, Remember that the audit requirements cover many businesses that don't consider themselves high risk. Do your threshold analysis now, whether it's 250,000 consumers' personal information or 50,000 consumers' sensitive personal information, and the 26.625 million revenue threshold. Plan backwards from your certification deadline. Uh, Give ample time to both conduct a pre-audit investigation and correct deficiencies before the audit period begins, as well as to find an auditor and make organizational changes if you need to. The audit should be focused on personal information, so begin with a California personal information data map, or if you're choosing to use California as a high watermark and it's more efficient, just a data map of all personal information from across the country that you collect. Remember that audit reports may become litigation or enforcement evidence. Remediate any deficiencies promptly and document those efforts. That is your best defense both from enforcement and a litigation perspective. And as I said, consider treating this as a nationwide exercise, not just a California project. So I got through that a little faster than I was expecting to. We have plenty of time for questions if anyone has some.
Yeah, as I'm waiting for the audience question, I have a few questions for you.
Sure.
Um, so we talked a little bit about the difference between the cybersecurity audit and the CCPA regulations and the general security assessments, and the fact that this focuses on personal information. But who within the organization should own, coordinate this audit process in your mind? Because it's sort of, in my, at least, most of them are security requirements, but sometimes personal information is in places that are not kind of part of security's purview. Like, for example, you talked about device IDs. It's not something that would fall under the critical, assets kind of umbrella. So how do you think that these audits should be coordinated?
That's a great question. It's certainly a cross-functional exercise. If you have a privacy team, they should certainly be involved. If you're using an external auditor, then I think that the technical team can work with the legal team or the privacy team to isolate and identify personal information. If you haven't performed data maps yet, you should to identify everywhere in the organization that holds personal information. That's really the roadmap for these CCPA audits, and then you can grab your ISO cybersecurity audits and adjust them or rely on them where they overlap to form the CCPA audit. If you have an internal auditor, it's a little bit different. Probably if you have an internal auditor, it's if you have an internal auditor, probably you're a large organization, and you'll be able to segregate. And then maybe the general counsel or someone who doesn't have control over the audit process can be in charge of this.
Yeah. And then I have another question, which is how should companies document evidence to show that their cybersecurity audit was conducted appropriately?
How should
especially
the
for those who are considering. I mean, you have the option of using external auditors, in which case they have a process in place. But if you are using internal auditors to certify, then, what are your recommendations?
Yeah, I'll be honest, I'm not an auditor. I think we would rely on the standards that there's four different examples of auditing industry standards that the CCPA specifically calls out. One of them is the ISO. Two others are one's for public companies, one's for financial auditing financial data. So I think the auditor, whoever that's internal or external, will just need to follow accepted industry standards for the auditing industry. And if you want to be extra safe, follow one of those four measures or organization, the standards of those bodies.
Um, in your mind, what are some common gaps people may find when preparing for these audit requirements? I mean, again, you don't have to be specific, but generally things that you may advise your clients to think about as they start thinking about next year's deadlines and why they should prepare now.
Yeah. Um, that is a very broad question. It really depends on the company. I have absolutely seen companies with 27 million in gross annual revenue who have little to no cybersecurity program in place, unfortunately, or they're relying largely on outsourcing their IT function or their cybersecurity function to a third party CISO. Um, I've also I've also seen smaller companies that have incredibly mature cybersecurity programs. So it's difficult to answer that question, but follow the tenets of I think it was 7123 Charlie, the 18 cybersecurity functions that the CCPA specifically outlined and map those onto wherever you collect or store or process personal data. So start with your data map and then follow these tenets of access control, of encryption, of multi-factor authentication, of whatever those 18 tenets might be, vendor management. To answer that question, actually, vendor management, in my experience, is a frequently overlooked cybersecurity function for a lot of companies. You do have an obligation to perform diligence on the vendors with whom you share personal information. So, if I had, it's a broad question, but if I had to pick one, vendor management is often overlooked, especially for smaller companies.
Yeah, I agree. I think vendor management, especially monitoring the process as agreed with, in the DPA or in the contract. That's an area. Retention is also an area where sometimes, we've had to, over the last few years, publish retention policies and follow them, but it's an area that is hard for many companies. Even a data map, I mean, because when you're subject to audit, how good your data map is will be put to test as well. So as you kind of look at your own privacy program and what you have in place, looking at the gaps in your privacy program might be a good idea, because when it's subject to audit, all of that sort of will become problems from an audit perspective. Um, so we may have already talked through them, but it might be more of a summary or, repeating some of the things that we talked about. But what practical steps can a small or a mid-sized company take if they do not have a mature security audit program today?
Yeah, this is the way that the laws are going now. So if you have over 27 million in revenue, the CCPA is going to require you to come up to speed cybersecurity wise. There are certainly plenty of third-party resources available. Like I said, you can sort of the third-party CISO. Meru data can help you, of course, with a lot of the uh, implementation and data mapping and the compliance work. Um, you've just got to come up to speed, whether that's through an outside consultant or hiring someone internally. Um, the 18 tenants are listed there. It really, again, don't forget there is that sliding scale built into almost every privacy or cybersecurity law that um, it's appropriate to the nature and scope of your processing activities and the size and complexity of your organization. And the regs also say the cost of implementation. So it's a bit of a legal keeping up with the Joneses standard that the regs throw in. You're not expected to be the Amazon and Googles of the world, but you do have to sort of do what companies of commensurate size and scope are doing to protect the personal data that you process.
Um, and I see a question here that's talking about, yeah, we will be sharing the recording after the meeting. In a day or two, actually, the recording will be published and will be accessible by anybody. But if you have questions or need anything in particular, you could also reach out to us. You can also reach out to Austin via LinkedIn, his LinkedIn profile, if you have any questions. If I'll kind of pause to see if there are any more questions, but if there are no more questions, then we can wrap up the presentation. Um, Thank you, Austin, for joining us and providing the details. And thank you, everyone, for joining us on this webinar.
Thank you, Priya, and thank you everyone for joining.